What is a common law trust? My name is Sot L, seeker of truth L, speaker of truth L. I would like to welcome you to this most current and recent episode of the Foundation. And we're going to jump into this topic right here. I think it's a convoluted topic. People get on here and they pontificate. They think that, they talk like they know what they're doing, all that dance. First and foremost, I want to say this, been gone for a while. I'm back. I'm good. Nothing happened. And I also want to say that, I feel like this information should be more readily available, right? And I feel like it should be put in more simplistic terms. So with that being said, the foundation, the mission is to reestablish the foundational knowledge of how you do business, commerce, what that means, all that encompasses, so on and so forth. So looking to do that, we will get into what a common law trust is, the powers, the benefits. We'll jump into some case law, might do a little extra dance. I'm not trying to take up all of your time at all because, that's not cool. Is it cool? It's not cool. You be taking up people's time and stuff, you know what I mean? So let's jump into this. Please, por favor, check out welcometothefoundation.com. Sign up for the email list. You see the mouse right here. There, right there. Sign up for the email list, exclusive information, invites, event notifications, promos, dances, bunch of dances, whatever dance you want to do. Along with the show, we have I would say the most comprehensive trustee training ever offered in the public. I'm not playing. This is it's a touchy subject for a lot of people. Comprehensive. Listen, at your own pace, learn at your own pace. You will learn trust administration, how to establish them, all of that stuff. This is the education dance. If you're looking to buy a trust, you're in the wrong spot. We adamantly believe in people, learning how to do this stuff themselves so that you can administer it. You can teach your heirs how to administer it, and you can start on that multi-generational wealth dance because you got to start somewhere, right? Link in the description if you want to sign up. It's very comprehensive. Like I said, learn at your own pace, do your own dance. No pressure. Link in the description. If you're looking to start your own business, I hope you are because they're laying off everyone. Everyone's getting laid off. Massive layoffs. They have to do them in waves. They can't do it all at the same time. They can't just lay off like a company, and especially these large companies. They got state regulation, and they get larger. They get, federal regulation. And, if you look into these laws, these state and federal laws, there's actually, provisions on how they how they can and how many people they can lay off and, whatever. So we're going to continue to see layoffs. I suggest that you start your own business. That's just it might not be my business, but if you're looking to start your own business, link in the description. I would say this list, listen, comprehensive from start to finish. It's not a race. That's what I would say. People sign up for this and they think they're going to watch a video or two and then, listen, this is going to take at least a couple days, but you're going to do your dance. And this is going to be information that you're going to retain it, and you're going to be able to use it. So if that's what you're trying to do, the link is in the description. And we have the Foundation magazine. We just recently wrapped up our cybersecurity issue. You can order back issues. Just shoot an email to support@welcometothefoundation.com. He will take care of you. He's amazing. But, we just finished up the cybersecurity. Man, it was like volumes. We did like three or four of those joints. The physical subscription is doing very well. We have a digital subscription and a physical subscription if you actually want a magazine, the old school dance. People like that stuff. So, hey, link in the description, do your dance. But real quick, I really wanted to do this episode because there's a lot of, in my opinion, there's a lot of I would say, misconceptions, confusion with regards to trust, what a common law trust is, Massachusetts trust, a business trust, all these different things. And with that being said, I also want to say that I don't like to use, primary sources, or as close to primary sources as I can. I don't like to go into the fringe and, deal with hypotheses and philosophies and go holler at Socrates. Like, I'm not trying to do all this stuff, right? So I think that A, keeps things more grounded and much more easier to digest, and B, it, I guess, presents, I just, I like to present as not a goofy, weirdo, crazy dude. Even though I might be crazy, you never know. Do your dance. Because, some people are crazy and they just hide. They hide it really well, man. And you don't know. And then you find out. And it's a mess. It's a hot mess. Hot garbage. So, I could be out of here. I could be straight up out of here. And on that note, I'm not an attorney. I don't give legal advice. Can't give legal advice. This is not legal advice. I've never given, nor will I ever give legal advice. If you ever say that, oh yeah, Sot gave me this legal advice, you got to substantiate that. You're going to play one of my episodes where I say on every episode that I might be crazy. I might. And I don't give legal advice. I can't. I'm not qualified. I'm not an attorney. Legal. Public. But let's not get into that. We're talking about common law trust, right? What is a common law trust? In a luxurious fashion. Came across this dance. Forbes.com, right? You know Forbes. I know Forbes. I'm familiar with Forbes. I don't know Forbes. Never met him. I know of him. I don't even know if it's a him. It might be a them. It might be a whole family of them. I don't know, man. But this is from 2021. Please believe they can change this at any time. I already got it. They can change it. I already saved it. I got it. I read this and was like, wow. Forbes is doing their readers luxuriously. Straight up. Okay, so check this out. What is a common law trust? Oh, well, Forbes was like statutory versus common law trust. Understanding the differences. So let's rock with this, right? There are many ways in which entrepreneurs can protect themselves and conduct businesses, such as through a limited liability company, statutory, S corporation, statutory, C corporation, statutory, trusts, statutory, possibly. When conducting business, people most commonly use one of those first three structures. Yep. For business owners looking for advanced protection, privacy, and planning, this is where trusts come into play. Let's move down here. Statutory trusts. Statutory trusts are regulated by the Uniform Statutory Trust Entity Act. Yep. Okay. That's important. They are based on the law of the state. The state in which they are set up. So these trusts vary by state. This type of trust can enhance privacy when conducting business. This is because the beneficiary of the trust is kept private. Ooh. This differs from other company structures such as LLCs, S corps, and C corps, where ownership is in the public domain. And they say public domain. We say public. But it's the same thing. Statutory trusts are often used for real estate and passing down one's assets to family members. Profits are distributed to beneficiaries, which can lead to higher levels of taxation. It's another form of income. It's another source of income. It increases one's income. Statutory trusts are often a good option for individuals with a net worth of $1 million to $5 million. This is due to the simple nature of setting up such a trust and its standard terminology, which is already templated out. This makes a statutory trust a much cheaper and quicker option compared to the more expensive common law trust. Well, I mean, if you're looking for convenience, yeah, you want to do that dance. If you're looking for cheap, you do that dance too. Common law trusts, these are often referred to as pass-through trusts or a pass-through trust agreement, which means the profits are passed through to the beneficiaries, similar to some statutory trusts. Common law trusts offer increased privacy and security similar to statutory trusts. Now, I would say statutory trusts are similar to common law. That's just me. They are based on advanced tax and estate planning rules, which can help individuals keep more of their hard-earned money. That's the point, right? Isn't that what we're all trying to do? Common law trusts are filed as complex trusts. Yes. The IRS recognizes 3 different types of trust, y'all. Grantor, simple, and complex. They're dropping knowledge in this article. I'm not playing. Using Form 1041, that's the federal form. The accounting and legal rules are different from those of statutory trusts. That's absolutely correct. Common law trusts are based on private contracts, which are linked to Article 1, Section 10 of the Constitution. This shows that nothing can come in the way of you and a private contract you create, which is what is created when you have a common law trust. Let's check this out. Article 1, Section 10 of the Constitution. Ooh, guess where I am? Article 1, Section 10 of the Constitution. This is Cornell Law School. It's a law school. I didn't make this. This is, I would say this is probably a secondary source, not a primary source. Section 10 of Article 1 of the U.S. Constitution. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money. You make bills of credit, make anything but a gold and silver coin a tender in payment of debts, pass any bill of attainder ex post facto law or law impairing the obligation of contracts, or grant any title of nobility. What are we looking for? What do we care about? We care about this right here. No state shall, follow me, pass any, this is crazy, man. When I first, this was crazy I remember. Pass any law impairing the obligation of contracts. Oh. No state shall pass any law impairing the obligation of contracts. We'll come back to that. All right? This supersedes statutory law and is directly filed at a federal jurisdiction. That would be the 1041. Allowing you advance rulings based on Supreme Court cases. Woo! Look. Who wrote this article? Who wrote this? Kuram. Kohan. Shout out to this brother. Shout out to Kuram. Issues with this type of trust include the expense of setting one up. Compared to statutory trusts, it can also be difficult to find experts who are, experts? I'm not a lawyer, but I might be an expert. Who are well-versed and able to speak on common law trusts. Common law trusts are best suited to high net worth individuals and family offices who have a team of experts who are well-versed in operating this type of business structure and can keep up with the correct administration of it. I have a problem with this. This is what I have a problem with. Best suited for high net worth individuals and family offices. Look, unless you win the lottery or, you start a business and, you're Jeff Bezos, this really makes it seem as though, let's just say, people like us shouldn't have these types of trusts. And I'm going to say this just off the bat. And this is not legal advice. This is experience spoken. You feel me? And what I'm going to say is that's absolutely false, man. I can't explain the benefits that my family, my estate has realized after, quote, going private. I mean, come on, man. I have to be in high net worth. No. And then how do you get to a family office? How do you get to generational or multi-generational or family wealth if you don't start somewhere? So I want to say this right here. This right here is just, this one guy, he cracked me up. Poppycock. He called it poppycock. Y'all was dying. I mean, that's poppycock. I was like, what? But I knew what he meant when I heard it, just by the context. But it still had me cracking up. So I'm going to, hopefully, y'all, that tickled you, because it tickled me. Poppycock. This is straight up poppycock, y'all. This is some bamboozlement. First of all, I'm not going to let anyone set rules and guardrails in my mind. And I feel like this is what this is. You got beyond informative writing, and that's an opinion piece right there. Informative opinion. What else? What's the other one? Persuasive. They didn't persuade me. Bottom line, there are many types of trust that can be subdivided into revocable or irrevocable, grantor or non-grantor, and so on. Each of them does things differently. This means that deciding which is best for your situation can get confusing quickly. To achieve the outcome you're looking for, it is important for you to do your own detailed research before you decide what's best for your needs. Statutory trusts are the more popular option for business owners, but for those who are looking for a more advanced solution, common law trusts are well worth looking into. Look, truth. What did he say? Where did he say it? This means deciding can get confusing quickly. And this is what I'm trying to cut through this confusion, right? So we have revocable trust. This is a trust that the grantor creates. You like that one? Creates? How many times you created something? You got the settlor. We'll say the settlor or the grantor, synonymous terms. Creates a trust, whether statutory or common law, doesn't matter, right? Private or public, doesn't matter. And the grantor or settlor retains powers over the trust, powers of administration, powers of revocation. They have powers to pull out corpus of the trust, powers to appoint trustees, to fire trustees. That's more of a revocable trust. That's not a separate entity. Irrevocable trust. This is what we're talking about. This is private. Private. The grantor has no power. Once the trust is created and the trustees sign on to administer the trust, the grantor has no power at all. None. Zero. At all. This is a separate and complete entity. A grantor trust is like I would say, pretty, I don't know, I don't want to say it's the same, but more often than not, I see grantor trusts are always revocable trusts. I can't think of any time I saw a grantor trust where it wasn't revocable. I have seen a grantor trust that was irrevocable, but only parts of the contract were irrevocable, because for it to be a grantor trust, there had to be powers of administration or some sort of benefit or control over the trust, which made it a grantor trust, whether it's irrevocable or revocable. Grantor trust basically means that the grantor created it and is the beneficiary. Created it and is the trustee, and then sometimes they're the beneficiary as well. And that's all bad. Non-grantor trust. These are trusts where, the grantor or settlor created the trust, but the grantor or settlor is not in control of the trust. Has no administration powers at all. Doesn't have access to the bank accounts. Doesn't have keys to the buildings. If that person, the grantor of that trust, went on the property, they would be trespassed. They would be arrested. They have no right. It's irrevocable. So, I just wanted to show you that. Real quick, let's jump into this. This is, Bouchard versus First People's Trust. And I just want to point out, it's highlighted, there's a sound and well-recognized distinction between a voluntary association and an express trust. So a voluntary association is basically a trust where the so-called beneficiaries and the trustees are kind of cooperating. And you want to avoid this at all times. Beneficiaries should have no power over trust administration, have no power over the trustees, and have no power over the bank accounts or disbursements, distributions, payments, nothing. They should have no power at all, because that is more of a voluntary association. This is number one. I would say, this would be number one. The number one attack that I've seen against these types of common law trusts, where people who don't know how to properly administer them and they get into trouble, it's going to be a voluntary association. You got the beneficiaries, and the trustees are they're either sharing powers, or the beneficiaries have a say. They have a vote. Like you see LLC corporations, they'll have shareholder votes. Oh no, none of that. None of that. The second thing that I see is commingling or self-dealing. And basically, for example, let's do an example. You have a little brother. He's mentally handicapped. Can't take care of himself. He was hit by a car and, had brain damage. And it's terrible, actually. It's really terrible. But good news is there was a large payout given to your brother, and it was put in trust, right? It was millions of dollars for his care for throughout his lifetime, because he's going to need care for the rest of his life. Now, all that money was put in trust, and let's say that you were appointed the trustee, and you were to administer this trust and provide the necessary care for your brother and make sure that he gets the care that he needs throughout his life. This is a one-time payment. It's a one-time shot. Now, let's say that you do that, right? 100%. And there's no issue. Commingling or self-dealing is you go buy yourself a car, basically. You're not supposed to do that. This is for the care of your brother. And this money belongs to the trust. And the beneficiary of this trust is your little brother. And you wouldn't have bought a car? Ooh. That was self-dealing. You're going to get in trouble for that. Commingling is, you putting your personal money in the trust account. You're taking some of the trust money, putting in your personal account. You're commingling assets. You're commingling title of assets. You're going to title, as a trustee, you can title anything in the trust. You're the trustee. So you title your personal car in the trust. But it's still your car. You're still claiming it as your car, and that's commingling. Those two things, commingling and self-dealing, and allegations of association, are the I would say the three main and top attacks that the Internal Revenue Service, and generally it's going to be the state Internal Revenue Service or the state revenue service, because these types of trusts do not file state returns. They're not governed by the state. Oh, wow. Let's move forward a little bit. This is the Hague Convention on the law applicable to trusts and on their recognition. This is an international document, and it's exactly what it says. Law applicable to trusts and on their recognition. This convention specifies the law applicable to trusts and governs their recognition. The term trust refers to a legal relationship created inter vivos or on death by a person, the settlor. Inter vivos mean they created the trust while they were alive. That's all that means. By a person, the settlor. Settlor is also a grantor when assets have been placed under the control of a trustee for the benefit of a beneficiary or for a specified purpose. So this is a trust. The convention applies only to trusts created voluntarily and evidenced in writing, because there's trust, they can exist due to someone just speaking of, especially if you have a witness who's like, yeah, I remember he said there was a trust. If they don't find the trust indenture, there's still a trust, and they're probably going to, apply to state statutes. But nevertheless, I want to go down here. A trust shall be governed. Article 6. A trust shall be governed by the law chosen by the settlor. What law is this? This is an amazing dance right here. The trust shall be a trust shall be governed by the law chosen to the settlor. Which means that the grantor or the settlor of the trust can choose a law that is not state statutory law. Article 7 goes into how local or state statutory jurisdiction is applied to those who have not chosen a law. Most trusts, especially the trusts that I see from attorneys, and this isn't from the attorney that's your friend, and he came to your house and he was like, hey man, and he printed you out a trust indenture that was private and said, don't tell anybody. I'm not talking about that. I'm talking about you call an attorney or you go into their office and you say, hey, I want to get a trust. They're all 100%. I put money on this. 100% within the document itself is going to say this contract is governed by the law of the state of whatever state that attorney is licensed in. I put money on that. 100%. But with a private contract, with a common law trust, with a private trust, the grantor specifies the law that governs the trust. Article 8, the law specified by Article 6 or 7 shall govern the validity of the trust, its construction, its effects, and the administration of the trust. In particular, the law shall govern the appointment, resignation, and removal of trustees, the capacity to act as a trustee, and the devolution of the office of trustee. B, the rights and duties of trustees among themselves. C, the right of trustees to delegate in whole or in part the discharge of their duties or exercise of their powers This is be an agency, an agent. D, the power of trustees to administer or dispose of trust assets, to create security interests in the trust assets, or to acquire new assets. E, the powers of investment of trustees. F, restrictions upon the duration of the trust and upon the power to accumulate the income of the trust. G, the relationship between the trustees and the beneficiaries, including the personal liability of the trustees to the beneficiaries. H, the variation or termination of the trust. I, the distribution of the trust assets. And J, the duty of the trustees to account for their administration. The duty of the trustees to account for their administration. This is the Hague Convention on the recognition. The Convention on the Law. This is the Hague Convention on the law applicable to trusts and their recognition. Now, the beauty of this, especially for those in the know and for wealthy families, is that with this type of trust, this common law trust, it's recognized to do business internationally, period. It needs no local authority. Any country signed on to this convention, your trust can enter that jurisdiction and operate in commerce, title vehicles, property, brokerage accounts, so on and so forth. The wealthy and the people in the know do not want their businesses subject to state legislation, the municipal legislation, the city legislation, so on and so forth. It's predatory. They can pass a state law and, steal their property, steal their business. It's happened before a lot. And those are people who just don't know. But these types of structures, they operate internationally. So if you're doing what I'm doing, which is, corporate structure, private wealth management, and helping, wealthy families and individuals restructure internationally, you need to know what the international structure is. And it's possible that most of you have never conceptually thought of an international structure, one structure that can do business in all of the countries. You don't have to create a new business nowhere. The same thing. That's very, very powerful. 5 benefits of an irrevocable trust. This is Fairfield, New Jersey law firm. I don't know. I just found this, right? I thought it was good. Estate tax benefits. The assets in an irrevocable trust are not subject to estate taxes. So placing assets into this trust can protect them during the probate process. Every individual estate is probated, which means every individual, their personal accounts, their business accounts, their retirement accounts, all of their assets, their cars, their property, all of it is probated. What that means is the state court probates the estate. It allows for the creditors to make claims. It takes its own little percentage, and then it distributes the whatever to the beneficiaries or to the heirs. Ridiculous. You pay tax on your income tax when you get your money, and you pay tax, sales tax, and use tax, right? And then there's a death tax. What? No, not with trust. Life insurance benefits. Another role this trust can play in your estate planning is as the beneficiary of your life insurance. This will ensure that your life insurance payout is included in the value of your trust rather than your estate, which may otherwise put you above the tax exemption amount. Beautiful, right? Also, the life insurance policy would be, in most cases, for people in the know, would be the, asset of the trust, which can be utilized for financing, so on and so forth. But, it doesn't belong to you, it belongs to the trust. Income tax benefits. Unlike a revocable trust, these trusts are viewed by the IRS in a similar way to an individual taxpayer. This means that the trust income is regarded as separate to your income, which can put you in a lower tax bracket. You understand what I'm saying? Like this stuff happens every day. Every single day. And, there's people who know this and there's people who don't. And just because you don't know something exists doesn't mean it doesn't exist. And just because the people that you trust and you think that they're the smartest people on the planet and they went to school and whatever, just because they don't know that something exists does not mean it doesn't exist. Then we have Medicare planning and qualification, right? These trusts can be useful as a tool for Medicare planning rather than having to reduce your assets or sell your stuff. In order to qualify for Medicare, you can place assets into trust. This way, they won't be included in your personal assets when you are trying to qualify for Medicare and Medicaid. A lot of people say, I booked a consultation because I want to talk to you, but I'm retired and I don't know if this will help. Man, what? I just feel like, when that happens, I'm not communicating properly. That's my fault. That's 100% my fault. Access to cash flow in an irrevocable trust doesn't mean that your assets stop earning income or that you lose access to this income. A carefully crafted trust will ensure that your investments are kept in the ownership of the trust, but that the trust is able to make payments to you on any income they generate. And the trust, there's control. Like you don't have to claim all the income. It's whatever the trust disperses to you. If you do it like that in the first place, I would recommend it. We have, a different kind of, blah, blah, blah. But that is definitely a benefit. Definitely a benefit. And let's jump into this. I got some, what is this? 101. It's a compiled list of citations, Supreme Court citations. And you'd say, so, well, what does the Supreme Court have to do with this? And I would say everything, right? A constitutional claim can only be adjudicated in an Article 3 court. What is an Article 3 court? It's the judiciary, right? And these are, constitutional courts, constitutional issues, constitutional questions, right? Well, this is, let me just break it down to you. An equity pure trust, is the trust that we're talking about, is a lawful, irrevocable, separate legal entity. It is established by legal precedent that pure trusts are lawful, valid business organizations. This is case law. These are excerpts. Y'all can take a screenshot, write this down, whatever. Do your dance. I might be crazy. I could have made this up. I might have sat down and just typed this by myself. Just like, let me just make something up that makes it look like I know what I'm talking about. Trust or trust estates is a legal entity for most all purposes, as are common law trusts. Dignity of a contract cannot be set aside because a tax benefit results either by design or accident. A pure trust is not illegal if formed for the express purpose of avoiding taxation. And that's significant, right? Because there's tax avoidance and tax evasion. Tax avoidance, your affairs are arranged in a manner to where you avoid tax obligations. Tax evasion is you operate in a certain way and there's padding expenses and buying of extra stuff and, little games that they're playing trying to evade paying that tax. A pure trust is established by contract and any law or procedure in its operation. Denying or obstructing contract rights impairs contract obligation and is therefore violative of the United States Constitution. That's why. This is a constitutional thing. This includes states specifically, as well as any state structure and or their agents. That would be the Attorney General, so on and so forth. A state licensed attorney. This is a powerful dance. If I hope you're picking it up, because this is some luxurious stuff, man. The court will support the trustees in carrying out the terms of their trust contract and agreement. That's amazing. We find it intolerable that one constitutional right should have to be surrendered in order to assert another. The claim and exercise of a constitutional right cannot be converted into a crime. There can be no sanction or penalty imposed upon one because of his or her exercise of a constitutional right. Trust property cannot be held under attachment nor sold upon execution for trustee's personal debt. It says legal and complete separate entity. Personal liability of a trustee cannot be enforced against the trust property. The trustee owned personally any amounts of beneficial interest. These certificates of beneficial interest can be attached. Doesn't matter. In the case of the United States National Bank of Omaha, Kaminsky, civil action number 77, within the District Court of Jefferson County, Colorado, the bank alleged that Kaminsky owed them $20,000. When he had no personal assets to seize after they obtained judgment, they tried to seize the assets of a trust that Mr. Kaminsky had set up a few years before. The bank's action failed and they were unable to penetrate the trust. I'm trying to tell you, it's a complete and separate entity. And this is really what I want to put in there. Any state, because it's going to come from most actions come from state revenue, and if you're not self-dealing, if you're not commingling, you have the proper contract, and you're administering properly, any action from the state, any demand from the state, it really necessarily impairs the obligation of a contract. Now, how do you stand on this? Let's say the state brings you to court as a trustee or brings the trust to the court and the state rules against it. You just got to appeal. You have to appeal. You have to get to a judicial jurisdiction. So, the matter can be properly adjudicated, because this is not a statutory issue. This is technically a constitutional issue. And any ruling from a state court that would necessarily bind or abrogate the trust contract itself or the trustees themselves from acting in accordance with the contract necessarily impairs the obligation of contracts, which is, violative of Constitution. This is how these are constitutionally protected entities. This is where the power lies, y'all. And, this is why this is a hot topic. It's a hot topic right now. 100%. But I just wanted to put this out here. I wanted to, kind of dispel some of the fog and just put it down, because look, you have structures that are created according to state statute. You got LLCs, corporations, C corps, S corps. I would venture to say the individual, I'm not playing. The individual is a creature of the state. The birth certificate has a state seal on it. So therefore, when it comes to taxation, especially on the state level, they get a piece. Why? Because you are exchanging your living, breathing energy in the commercial market through their structure. I don't care what you're talking about. But now when you're dealing with a private structure or contract, the state has no governance. The state can't say anything. The trust's indenture says what an expense is. The trust indenture says what the trustees do. The trust indenture says what corpus is. Anything outside of that violates the obligation of contract. That's why these things are so powerful. That's why people want this stuff. That's why people sell trusts. All these organizations out here, we got a common law trust, we got the master trust, we got the private trust, we got you. No. You will never buy a trust from the foundation. Not as long as I'm alive. It will only be the education. I think selling you a trust without the proper administration education does you a complete and utter disservice. And this stuff is for generations, because the trust never dies. So not only do I believe that we are reestablishing our private estates, so I'm dealing with your ancestors, but I got to deal with your heirs too. And I'm not trying to incur that type of karmic debt. Do you understand what I'm saying? Money comes and goes. This is not a game. And this is nothing new, y'all. It's nothing new. It's just we go to public schools created by the states. There's federal implications with regards to that too, because these schools accept federal funds. But the bottom line is a public education to teach you the public things and how to operate in public with the public dance. You're not going to learn private dance in the public. I don't care how many letters you have behind your name. That's controlled knowledge. That's what they want you to know. That's what they allow you to know. And I don't, I respect you. And I respect your very narrow field of knowledge. But, that doesn't mean necessarily in any way, shape, or form that outside of this public information, there's an understanding with regards to how to privately administer business, estates, contracts, avoid taxes, and the true understanding. Oh, it's a state structure, man. It's their thing. You're using it. So you got to do your dance. Oh, it's my money. Man, listen. That's why I don't get into all that stuff, y'all. Not at all. I think it's a trap, y'all. I mean, hey, 100%. But look, with that being said, I trust that you have a more complete comprehension of what a common law trust is, the benefits, some of the detriments. I trust you understand the powers. I trust you comprehended some of the case law. But most importantly, I trust that you have the requisite knowledge to understand who is BSing you with regards to the trusts and who's not. And if you're interested to learn how to administer trust, there's a link in the description. Or you can email me, admin@welcometothefoundation.com. We can talk. You can also book a consultation at welcometothefoundation.com. It's the same price. It's been the same price for 10 years, $55 1 hour. And most of the time we go over. So, link in the description. You want to sign up, learn how to administer trust, set up trusts, administer trust. I think that's important. You can teach your heirs how to do it. Instead of, gurus come and go. People with knowledge, they pass away, they move away. But, if you keep it in-house, you keep it in the family, I think, that's where the power lies. So I trust y'all learned something. Y'all enjoy yourself. Take care of yourself. Make sure you say 10 things that you're thankful for before you go to sleep tonight and every night, because it's very important. It's very important. Yeah, I'm back. Y'all relax. Appreciate y'all. Y'all have a great night, great week, great day, great month, great year. And I'll catch y'all tomorrow on Current Events. Peace, y'all.